Hello, everybody, and welcome to Boomer Time. I'm your hostess with the mostest, of course. It's Nancy Cogar, and I am so glad you're here. We're always talking about issues that come up as you age and things that help you to be better prepared. Well, today we are talking about executors gone bad. Yeah, when they go bad, you just put money together with someone who shouldn't be in a position, and it causes big trouble. So, first of all, I wanted to let you know that you should be careful about who you choose to administer your estate. Today, as I said, we're talking about executors behaving badly. These are the folks that you name in your will to take charge of your affairs when you die. You know, these are the people usually that you put in there that you trust the most in life, right? Well, these are the same folks who you are expecting to follow your instructions in that document. Well, people are people, right? And sometimes, oftentimes, it doesn't go the way you expect it. And actually, it can go way off course. I'm talking about executors stealing estate funds, running off with money, forgetting to tell the court that they have other family members, selling houses without telling others or getting their consent, ignoring duties that come with it being an executor, unnecessarily delaying administration and distributions of estate funds. You name it, it's happened. And I'm going to share a few of those stories today. And you know what? It's my hope that you will think more specifically about who you leave in charge of your affairs after you're gone. In this episode, we will cover specific examples of executors behaving badly, look at warning signs for you that an executor may be breaking or even bending the rules, and maybe most importantly, what you can do as a beneficiary to take action in these circumstances. So, I'm going to start by saying it's true that the individual you appoint as your executor must petition the court to be confirmed, right? And receive what are known as letters testamentary. Those are the certified documents issued by the court that officially name your appointee as executor or personal representative of your estate. And those letters give them the authority to close and liquidate bank accounts, investment accounts, sell vehicles, sign deeds, sell property. Well, in fact, they are supposed to represent your estate and follow your wishes. But like I said, that does not always work out the way that we want it to, does it? So here are a few examples of executors acting badly. Ordinarily, executors have a fiduciary duty to the beneficiaries of the estate. What does that mean? That means that they have to act in good faith and in the best interest of those those beneficiaries, rather. Executors are fiduciaries, like I said, and they cannot act on their own behalf. But unfortunately, sometimes executors engage in misconduct, which can create problems for beneficiaries. Participating in theft, misappropriation, embezzlement, stealing, right? Harming the interests of the estate and the beneficiaries, taking what they want, first dibs, right? And ignoring the specific provisions in the will. Mismanaging estate funds, excessive spending, charging the estate, unauthorized spending, or all-out misappropriation. What's that? That's called fraud, right? Failing to pay executors' creditors, or estate's creditors rather, failing to pay taxes that may be due, failing to pay other expenses, ignoring all those expenses. So part of their duties are supposed to be resolving claims that come into the estate. But if they ignore them, guess what happens? This is called intentional negligence, right? And it could lead to liability to you as a beneficiary to pay back money to the estate. Talk about painful, right? Well, I've seen executors withholding inheritance from beneficiaries or needlessly delaying the administration of the estate for their own benefit and making unreasonable demands on beneficiaries in exchange for information or assets. You know what you call that? Extortion, right? Hiding, omitting, and otherwise misrepresenting estate assets. Stealing, that's what that's called. Collecting inflated fees. Fraud, right? Even disobeying court orders. Contempt. So, now, Nancy, you're probably saying this can't be true, that your own family members would commit what appear to be crimes, right? Unfortunately, the answer is yes. And even when it comes to misappropriation of funds, bank accounts, etc., when someone is helping care for an older adult, more often than not, that is the same person who's stealing from the kitty. Now, that's not true all the time, right? But more often than not, when we see exploitation of a vulnerable adult, something like that, it's somebody they know, somebody in the family. So, sounds like these executors could be breaking the law, right? Well, it is stealing. This is the type of misconduct that often leads to legal action against those executors and lawsuits by beneficiaries attempting to recover misappropriated funds. So I want to talk about what you can do as a beneficiary. And we're going to talk about that more specifically when we come back. Welcome back. What people will do for money, right? Well, we are talking about executors behaving badly. So a probate estate is how you administer an estate. Sometimes there's real estate to sell. Well, can you believe that some executors fail to tell the court that they have siblings or other family members? Unfortunately, this is true. So how could that happen? It happens. Another newly appointed executor was issued his letters testamentary. Okay, this is a true story, and went directly down to the bank. That's okay. He closed the deceased bank account, which he has the authority to do, and the bank issued a cashier's check to the estate. That's all normal. Well, here's where we take a turn, okay? The executor did not open an estate account. Instead, he left town and he opened up an account in another state by endorsing the check himself and depositing it as an inheritance. Creditors were left hanging, as were the beneficiaries back here. It all led to an expensive legal battle, unfortunately, without much result. Here's another one for you. Imagine an executor using estate funds to finance a lavish lifestyle and pay their own personal debts. Happens. So, such self-dealing is not only unethical, but it's also illegal. Legal actions can seek to recover misappropriated funds, but you know what? Sometimes when those monies are spent, there's nothing left. And really, the damage to the family relationships may be irreparable, right? So what can you do if you're a beneficiary and you suspect this type of activity with a loved one in another estate? We're going to talk more warning signs, or red flags as I call them, when we come back. Well, poor Tom Cruise, right? He did not fare well after his father passed away. Got worse too, right? He found out he had a special brother, Dustin Hoffman, who had intellectual disabilities, and took him for quite the adventure. Remember that? I love that movie, Rain Man. He liked to watch Judge Wapner, right? Well, we are talking executors gone bad this episode, and before the break I said, what can you do if you're a beneficiary and you suspect this type of activity in a loved one or in another's estate? Well, I wanted to talk about warning signs or red flags. I've represented heirs who have suspected that the appointed executor is up to no good. And sometimes, you know what? That is the case. Sometimes it's exactly what's going on. So I thought it would be helpful to talk about a few warning signs. If you find executors acting badly, you're going to want to take some action. And you have rights. So watch for these 9 red flags. And I get calls about these all the time. Number 1, ignoring the beneficiaries. The law requires notice to beneficiaries throughout the probate process. So part of the executor's job, really his or her duty, is communicating with beneficiaries at different stages of the administration. But I get calls from people, I have not heard this, I have not heard that. It's been months, months, months. And if the executor has not provided you with the required probate notices or has failed to respond to your requests, obviously that's a red flag that the executor is not doing the job correctly, right? How about just outright neglecting the duties? You'd be surprised at how often this happens. A person, maybe a sibling or relative, gets appointed as executor and then does nothing, just sits on it. I get calls about this issue all the time. The executor is sitting on the will, sitting on the estate, refusing to move forward, refusing to file anything in court, refusing to communicate like we already talked about, refusing to move forward despite requests from beneficiaries to administer the estate. They don't know what's going on. They don't know what to expect. They require notice. So perhaps they did not hire an attorney and this executor just doesn't know what to do or how to do it. Well, in my jurisdiction here, you have to hire an attorney to probate an estate. I'm going to talk more about what I see the judges doing under their discretion to try to protect you a little bit more towards the end of the episode. But stay tuned for that, okay? Missing important deadlines. That's also another red flag. There are several very important deadlines associated with estate administration. There are deadlines to send required notices to beneficiaries. I've talked about that. For filing disclaimers of interest in the estate. For making advance payment of possible inheritance taxes, which can lead to discounts. Filing tax returns, paying taxes, like I said, and ignoring claims, not settling those, delays in filing an inventory and status report. These are big problems. There are many other deadlines, too, that are part of the process. It's really complicated. So most beneficiaries, and it makes sense, are unaware of these deadlines. An experienced estate administration attorney like me can inform you of the deadlines so you can assess whether the executor has gone bad, is missing the deadlines, and maybe costing you and the other beneficiaries substantial money. We talked about this one before, self-dealing. Self-dealing occurs when an executor uses their position to act in their own best interest instead of the interest of the estate or the person who signed the will, right? The deceased person. When you have access to assets, it can be tempting for executors to sell those assets to themselves, right? For below market value. Hey, everybody. Yeah, I know this house needs work. How about I take it off your hands? And you make a lowball offer. Well, that's not going to work because the court is requiring before you did something like that, that you file notice and get approval. And that is self-dealing. So that is a no-no, especially if you're executor. Other examples include using estate assets, going on vacation. I've never seen that one, but it's Sure, it's happened. Uh, Not paying rent to the estate, using the assets for the exclusion of the beneficiaries, maybe investing it and making money for themselves. I tell you see it all. There are so many more examples of self-dealing, and the longer you let that kind of thing go on, the more difficult it is to undo. Here's a simple one that I've talked about: not hiring an estate administration attorney. Okay, it's required where I am, but executors are not expected and often do not possess the know how and the skill to settle an estate. Simply put, without legal help, executors are almost guaranteed to make mistakes, right? Or it just takes longer to settle the estate. And normally, it could take up to a year before the estate is closed. So that would just prolong that even more. The usual excuse is, I want to save money. I'm not going to hire an attorney. But the cost of the attorney is part of the process. It's usually a cost that's part of the estate's cost. It can be deductible for tax purposes, and it reduces, the possibility of having real significant problems. And those problems could be shared by the beneficiaries. The impact of an attorney fee on a beneficiary is really minimal. So you need the benefit of having quicker administration and avoiding these costly mistakes due to just simply a lack of knowledge. How about, this sounds like the one I mentioned earlier, not collecting or marshaling estate assets into an estate account. So the executor has a duty to marshal or collect all the decedent's assets. That's part of the process. So those assets can be distributed once, the costs and expenses claims of the estate have been settled. One costly mistake that we see is when an executor holds those assets and doesn't do anything with them. Say it's an investment account, and let's say the market tanks, right? That downturn in the market could cost beneficiaries tens of thousands of dollars. Another problem is leaving money in an account that has automatic withdrawals set up. See that all the time too. People do that more and more these days. The withdrawals continue for the service that the decedent no longer uses, say Netflix or, one of those subscription-based services. You're not going to get that money back. You just have to stop it. Not safeguarding the estate against identity theft. This is one you may not realize, okay? Each year, identity thieves use the identities of nearly 2.5 million deceased Americans to fraudulently open credit card accounts, apply for loans, get cell phones, all kinds of things. It's called ghosting. And because it can take up to 6 months for financial institutions, credit reporting bureaus, and the Social Security Administration to receive, share, and register death records, it gives them, the crooks, bad guys, ample time to rack up charges. And guess what that's going to lead to? A claim against the estate. And that would cost the beneficiary big money. There are steps an executor can take to prevent ghosting, but it takes action. Right? It takes know-how. These are just inheritance draining claims. And I, wish I didn't have to say this one, but not following the terms of the will. I had somebody ask me after their parent died if they could change the will because they didn't like the way it flowed. Absolutely not. Executors must follow the terms of the will, and that's easier said than done for most executors because wills often contain all this legalese, words of art that are difficult if you're not a lawyer to understand or decipher. So what about providing for allocations of taxes and, all these kinds of things? Executors, they're not generally able to do those types of things. They need help. And just one simple mistake can result in some beneficiaries paying too much tax. or cost the estate, right? So there's less coming out in the net. These executors who outright don't even follow the clearest provisions in the will. Give Jane my X. Well, they decide Jane doesn't deserve that, so they're going to give it to Bob. These situations require urgent action. Sometimes, believe it or not even producing the will. They have an obligation to do that. And destruction of the will, hiding it, is a Class E felony. And that will lead to jail time. But you know what? If it involves money and it involves people, you know these things are going to come up. So this is a long list of red flags. And it's just a few. There are more. But suffice it to say, if you're an estate beneficiary who feels the executor is not handling their duties properly, you should not let this problem continue. Because as losses can keep adding up, you do have options to address the situation, but the best advice I can give you is contact an attorney who can represent you as a beneficiary, because if there is an attorney involved in the estate, he or she is likely representing the executor. Before we close out today, I wanted to talk about what you can do if you find yourself in a circumstance like this. I mentioned you have rights, right? And as I mentioned before, an executor is a fiduciary and can face significant legal consequences, including being personally liable to repay money to beneficiaries, potential fines, even criminal charges, depending on the circumstances. Essentially, the beneficiaries would be left with nothing to inherit, as the estate would be depleted by the executor's actions. I talked about a situation like that. Depending on the jurisdiction, the executor may face penalties like being forced to reimburse the estate for misused funds, paying legal fees associated with the lawsuit against them, criminal charges for what really equates to theft or fraud, right? If the situation is severe. I'll tell you, at least in my county, here in Hamilton County, Tennessee, you are going to need the court's assistance and action when it comes to many things now, because of all the fraud. So you need court action to assist with the sale of real estate, for example. You're going to need an order of the court authorizing the sale, and the net sale proceeds, that check that you usually get at the closing, well, they get paid into the court now. You don't have a choice. The judge says that's the way it's going to be. And you will find that the title companies often won't close real estate without the court's blessing. And that's just because of this bad conduct. What are you supposed to do if an executor is mismanaging funds? Well, I say review my red flags and seek a lawyer's help. And as I always say here on Boomer Time, you can call me for a strategy session and we can work through these types of issues. You don't know what the documents say, we can review those too. And we can, possibly request an inventory, financial statements, and those say a lot about what's coming out of the estate. And if worse circumstances, you can petition the court to have the executor removed and have someone else appointed. Oftentimes that's a public administrator or a court-appointed administrator. And that's just what happens. So here in Hamilton County, we do have a proactive probate judge or chancellor, and we've had some of these types of things come up with so-called fiduciaries of the estate. So the court has changed procedures, as I've already mentioned, in an effort just to better safeguard assets and hold these executors responsible. Still doesn't eliminate the problem, right? But it's good to know about these things, and that's what I try to do here on Boomer Time. So I hope you've enjoyed and learned something more appropriately from executors gone bad. And we'll go back and look at some of these issues more specifically and in depth on a future episode. So don't forget to follow me on Facebook and on YouTube and Instagram, and subscribe to my newsletter, nancycogar.com. You can do that there, and you can reach me there too. Well, that's about all I have to say today. And, I hope I haven't made you too afraid to appoint a family member and a loved one, because not everyone's like this, but just be wary. Okay? I'll see you next time.